thing. Good afternoon, everyone. Welcome back for this afternoon session of International Faculty Development Program Day 2. The session will be headed by Professor Dr. Prasannanshu. It is a moment of extreme pleasure to welcome Dr. Prasannanshu as our speaker. Sir will be focusing on the topic the importance of language, literature, and communication skill in curriculum of law and legal research in this session. Before starting the session, I would like to introduce our speaker, Professor Dr. Prasannanshu is a professor at National Law University, New Delhi. He has done his MPhil and PhD from Delhi University. He also presented various seminars and delivered lecture globally. He delivered a talk to faculty member and research in a conference titled Elements of Humanity in Legal Education and Interference of Literature, Language and Communication Skill in University of Paris, France. In addition to his responsibility as a professor at National Law University, he is also a director of Center for Linguistic Justice and Endangered Language and project coordinator of study and research toward preservation and promotion of indigenous and endangered languages. Professor Dr. Prasannanshu was also the member of Publication Committee of the Linguistic Society of India from 2018 to 20. Professor, he has also chaired sessions in several seminars and conferences and has been honored a chief guest at the function of couple of education institutions. He has also been an examiner and guide of PhD and a subject expert in the interview committee for the appointment of university teachers. It is our privilege that Sir has joined us today. Now I hand it over to you, Sir.
Thank you very much. It's my pleasure to be at Starex University today. Uh, Before I begin, may I request everyone to please turn on their cameras. Mirror topic. So there are many new and promising universities that are coming up in Delhi, NCR, and across the country. And it is such an exciting time for academics, I would say, that the education is spreading. And the private universities like this have a great potential and promise. I think we are recapitulating or repeating the history like a couple of centuries ago, or especially during the last 2 centuries. Several private American universities were established, and now they are global leaders. And I think this is the time, this is a historic moment when these big, geographically big in size and also resources universities are coming up, and I think they will be able to give a leadership role in academics to India. Thank you very much. I thank the head of the department who is there in front of me of law, and Professor Rana, the Vice Chancellor, the chairperson of this university, and the registrar for giving me this opportunity. Today, I am going to talk about law, language, literature, communication, and their interface. The exact topic you can see that has been introduced, I think. And before I start, I see some of my students, colleagues, and I welcome all of you, Nitesh, Dr. Pratima Dubey, Associate Professor. It's still Ms. Pratima Dubey in your description. You are Associate Professor now, Dr. Pratima Dubey from National Law University, Gujarat. It's a pleasure. And another thing I would like to say is you can lead the discussion or what I am going to say today. Perhaps you can ask questions. You can start with asking questions. I told you, I have given you a lead that the topic or what I am going to talk is about the interrelationship between language, literature, communication skills, and law. So while I take a sip of coffee, maybe you can formulate a question that will give the direction to today's talk. The first, Kalpana Thakurji has raised a hand. Yes, please. Please ask. Kalpana ji, are you able to hear me? Okay, okay. The technical team is unmuting you. In the meanwhile, others can also raise their hand. So the first most provoking and strange thing is that I am claiming that there is something that language, literature, and communication has to do with law. So all of you, please be provoked. Please think. Do you think that this is true or they can have any relationship with each other? There is a scholar here, Dr. Puji, Mr. Nitesh Kashyap. He has worked on judicial activism. So, Mr. Nitesh, do you think that there is any relationship between language and law? Okay, he thinks yes, there is. Kalpana ji, are you able to speak now? You are unmuted, you can say. You can speak. Okay, okay, okay. Sorry. It's fine. See, law is, there are two dimensions, first of all. One, law is an outgrowth of humanities or philosophy, and very specifically within philosophy of humanities, or the branch of humanities. It is not different. And language, literature, communication, etc., they are parts of humanities, characteristic, trademark parts of humanities. So these are sister branches from one perspective, if we want to look at it in this way. And otherwise, they are all interrelated. The division is only for the convenience of studying, of comprehending. But these divisions are not real divisions. Sometimes we take the divisions very seriously. We treat them like watertight compartments. We treat them like races. We treat them like species. We treat them like castes. It is not good. And we all know that racism is not good. It is, we know that casteism is not good. So this is a type of academic casteism, academic racism, which we have to remove from our minds. We have to open our minds. We have to broaden our horizons. When we look at things in a holistic way, then I think we are going to do justice to academics. This is the first thought. You can call it sutra. I think most of us understand Hindi here. So the first sutra or thought is this, that interdisciplinarity, which is a fashionable word, should be a reality of our thoughts, of our minds. It should be a mental reality, not just something that we throw at in conferences, in others' faces, or in meetings, etc. Now, coming to the very specific point, law and language. Law is a profession of letters. I am quoting a very illustrious writer, a researcher, and I agree with it. That is why I am sharing it. And I think this is very clear that from at all stages, whatever the stages of law are, or whatever the different parts of law are, they are all connected with language. So maybe we can explore this first, like what can be the different levels at which law is practiced or exists where law exists. Let us explore those parts. Like the first may be the client interview, when as an advocate you meet the client. So how this client interview takes place? It is in language. Likewise, and here there is an interplay of language and communication both. Language and communication are interrelated. I will try to explore the relationship between these two soon. But for the time being, maybe you can take them, use them interchangeably. After that, after the client interview, upon which a lot depends. For example, the rapport between the advocate and the client, the understanding of the issues both by the client and the advocate, that takes place in language, and that is an important communication. The next stage is when you are drafting and pleading in the examination in chief, in cross examination, in writing of the judgment, in uh, drafting your contracts. In all these, what you require is language and communication. There are many, many concepts of communication which I will try to fit in this short while. Then you come to the next level. The next level is the legislature's level, the law commission, the drafts are made. You have to draft the laws, the bills in language. And this language essentially has to be effective. If it is not effective, if we are not able to communicate clearly, succinctly, precisely, what is the intention of the lawmakers, then the whole purpose will be defeated. In the parliament, in the legislatures of different levels, there are debates, discussions, that is again in language. So at all levels and many other peripheral and integral levels of the process of law, language is essential. So this is a relationship. Now, when laws are formulated in language, laws are discussed in language. Thank you very much, Nitesh. And when laws are interpreted in language, laws are communicated in language, then obviously language is very important. It is a matter of some concern that in professional education, we have taken just one aspect of professional education, that is law. Language is somehow considered to be secondary. I see an engineer also in this meeting, Vimanyu Veer, and what I am saying applies to you also. Somehow we think that the professional course that we are doing or we are teaching, that is something like main and other things are peripheral. I think this is flawed thinking. I have given you two sutras if you want, or two thoughts till now. One is interdisciplinarity. Second one is that law is a profession of language, and any other profession also you can just fill in the word, your profession there. All professions are professions of language ultimately. My profession, I am a teacher. My profession is also a profession of language. So this is the significance of language. And when the significance is there, then it should not be considered as secondary. Like in food, we think that the spices, condiments, salt is secondary. It is not. Many things will not be edible at all without these essential things. But the simile is flawed. I am not agreeing with this simile that language is not like salt and spices. It is the main course, it is the main meal. But for the convenience of understanding, I use this example. So this has to be kept in mind. Now let me come to the concept of language and communication. Communication means how to share our thoughts, ideas and emotions. This is a cliched definition which I have used without much modification. Ideas, thoughts and emotions. They are shared. How we share with others, that is called communication. Now, there are three main means of sharing ideas, thoughts, and emotions. Basically, they are one and the same thing. But let us classify them into ideas, thoughts. I don't really know what's the difference between these two, and even emotions. So let us try to analyze that how they can be communicated. They can be communicated by three means basically by human beings. One is the verbal means, that is language. Second is non-verbal, that is body language. And the third one is paralinguistic. So what is paralinguistic? That issue let me take up after a few minutes. First of all, language is part of communication, or we communicate using language also. This is to be understood. In law, in all the stages that I mentioned, there is communication. Language is a tool of communication. It has many other functions also, but ultimately it's a tool of communication. So language is required, but how important is only language? Within communication, it is said that language may have a role as little as 7% of the whole communication. 55% of the communication, according to Mehrabian, writers like Mehrabian and Birdwhistle, may be non-verbally, that is by body language, and 38% by paralinguistic communication. So now let me elaborate these three aspects. What is linguistic communication or verbal communication? It has four parts. One is reading, second is writing, another dimension is speaking and listening. These four parts, all of this constitutes a minority of the communication in general, even in the courtroom, as is exemplified by the dramatic courtroom scenes in the movies. We see that a lot of nonverbal communication plays a role more than what is written, what you say in strictly legal terms. Second is nonverbal. Nonverbal has basically five parts or six parts. It is called eye contact, facial expressions, gestures, posture, space and distancing, and appearance. All this is also very important for a lawyer for communicating. And in legal education, it is important that all these aspects are formally and in a very effective way given to the students. I have done my part already. Around 2010, the Bar Council of India constituted a course development committee for model syllabi for all law schools of India, law institutions, schools, universities, departments. Around 1400 of them are there. So I was given the opportunity of drafting the syllabus for language, humanities, etc. And in that, I have given a place to all these aspects. The three aspects, that is language, literature, and communication. I am still on communication. Let me explore it. But yes, being a democratic country, this is not binding. We have different states, different cultures, different languages. So all universities are free. Many universities have taken those suggestions. And what I am saying, I think those suggestions are in line, in tune with what I am saying now. So the second part I was talking about was nonverbal communication. Nonverbal communication is very important. That is why even in this online mode, the first thing I requested everyone was to turn on the cameras. Because as I told you, what are the parts of nonverbal communication? Parts of nonverbal communication are facial expression, eye contact, gestures. What are gestures? Your hand movements, posture, how you sit. Yeah, thank you very much. At least two people are listening to me. So, posture is how you sit, how you stand, how you walk. Space, distance, space and distance, that is maybe not communicated by the cameras. And that is why it is always better if we can have in-person meetings. And appearance, of course, you can see. All these things can be communicated by the cameras if we keep the cameras on. Now, do you see the difference? And you would see a reciprocal difference in my way of speaking also. Because did you notice it? There is a change. Why there is a change? I was talking to a blank screen. Now I am getting a constant feedback. If there is no feedback, then no communication is complete. This is a basic theory or supposition in the field of communication. So now I am getting a feedback from you. I am able to communicate in a better way. Did you notice this difference? I think you noticed. That's great. Thank you. Yeah. There are some very great experts who can talk to a camera for 2 hours or 5 hours, but I have not reached that level of accomplishment. I really require people to talk to because I am a communicator. I communicate. And in the courtroom, you are a communicator. In a classroom, you are a communicator. You are not just someone who parrots, who repeats like a parrot some things that are fixed. And that is why in the beginning, I also said that you are free to ask questions. And I am ready to change the course of my discussion at any moment. That is communication. Now coming to the third part, which according to authors like Mehrabian and Birdwhistle, constitute only 38% of communication, that is paralinguistic communication. So can anyone tell me what is paralinguistic communication? Any idea? Some of you might have heard of it, and there are some experts like Dr. Dubey. So
Thank you, sir. It's very nice of you to call me an expert, but I am nothing in comparison to you, sir.
I would, yeah, thank you very much. See, paralinguistic communication is about the voice quality. It sounds, yeah, body language, madam, is more about, and gestures are non-verbal communication of body language. Yes, tone, pitch, all these things, voice quality, very good. I am getting a lot of responses. Anandata Gaur, Akanksha, yes, articulation, good, good. Kalpana Thakur, voice quality, all these things. we can again classify them into a few fixed elements. That is paralinguistic communication, modulation of voice also. So paralinguistic communication is about how we speak. I will give you some examples, like over a phone, not over a video call, voice call. Don't you start thinking about the other person, who it is? And it is essential for us. It's an evolutionary fact that we have to know about the other person. Why? We have to know whether we can trust the other person or not, whether the other person is dangerous, the other person is friendly. So, some very basic things we start deciphering. Can you tell what you start thinking when you get a call from an unknown number? Like, even before you start deciding whether you know that person or not, what are the basic things? Let me give 2 or 3 things. Yeah, what would be the reason? Before that, whether it's a man or woman, don't you automatically calculate it? So that is the first thing. Second thing, maybe the age of that person. Yes, motive, dhanya, dhanya or dhanya. Both have meaning, the way you pronounce. Who you are you asking me or you are? Well, there was a big description of me if it is about me. And if you want, I can spend half an hour on describing in brief who I am. So, second thing is age that you can guess. You can also guess about the educational level of that person, motivation of that person. Yes, the way they say hello, you start deciphering, you start thinking of about that person. And I tried to list all this. I could list more than 100 things. I can give you some examples whether the person is trustworthy or not, the person is enthusiastic or not, the person is tired, the health status of that person, the person is hungry or not, and the emotional states, angry. Almost 100 things once I listed. And there may be 1,000 or more things, maybe more, which we start interpreting the moment we hear something. You are not even listening to the words. And this is very important in interviews also. Any type of interview, whether it's a job interview or a client interview. In the courtroom also, the way you say the thing is important. See what I am saying. Let me share something to recapitulate what I have said till now. Whatever I am saying is nothing startlingly new. Dr. Pratima Dubey, I know her. She's there with her camera. I know what she knows. So she knows that I am not saying anything great. Have I said anything great, madam? But what is important? What will reach all of you is not that it's some path-breaking content. The way I am saying, that is important. The way I am behaving or...
Yes, sir.
Yeah. Thank you. So,
Getting
madam,
everything is important, sir.
yeah.
So the reason I'm not speaking too much is because I am down with viral fever and I'm unable to speak much, sir.
Congratulations, madam, that you are down with viral fever, not its cousin, the corona fever. So there is always something positive we can look at.
Yes, 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 yes.
So enjoy your viral fever and get well soon.
Yes, sir. Thank you, sir.
Yeah. So in communication, the content is important. That may be 7%, but the more important things are because we learn or we pick up or we accept anything when we trust the other person. And this trust is based upon your non-verbal communication, your paralinguistic communication. So summing it up, in paralinguistic communication, basically it is tone, pitch, frequency, amplitude, pauses. Amplitude is how loud you are speaking. It should be appropriate. In all these things, everything should be appropriate as much as is required. Suppose I am sitting in front of a camera, I start shouting. It will look very inappropriate. And in case I am in front of my class of 120 students, and if I speak at the same amplitude, nothing will be communicated. The speed of speaking is important and the pauses. There are two types of pauses. One is nervous pauses that may be called non-fluencies. And the second is the type of pauses I am taking. I am giving a break after every word or after every phrase, after every sentence. What is the purpose of these pauses? I am giving you time to imbibe and interpret because our minds take some time to interpret. It's a time consuming, energy consuming process to listen. This is the purpose. So now let me recapitulate again. There is unity of all knowledge. Number two, law and language are interrelated. Language and communication are interrelated. Communication has three parts. One is language. The second is non-verbal communication. Third one is paralinguistic communication. Now an important thing is remaining. Let me try to express it in 10 minutes so that 10 minutes remain for you to ask questions. That is literature. The importance of literature in the profession of law. This is an introductory lecture. My purpose is all of you are learned people. All of you are teachers or research scholars. I am just hinting at things. These are the directions in which you can explore. So what can be the relationship between law and literature? I ask this open question again, if anyone would like to answer. One of the answers can be that there is no relationship. That is an acceptable answer, yes. If I say that, will you accept it? Law and literature. My question is that there is a relationship between law and literature.
So, on the face of it, it may appear as if there is no relationship.
Yeah. But there
But
is,
if you look deeper, but if you look deeper, you will discover that literature helps with law in some way or the other, indirectly or directly.
Thank you very much. Anyone else? A lot of people want to join this in the last 20 minutes, last 17 minutes of the conference. That's very encouraging. It's like, when you have a real evening and there are guests who are pouring in to the last moment. That generally happens in a prayer meeting, Everyone comes around the time of the lunch. Good. So Karishma ji is saying, since literature reflects the happenings in the society, I couldn't read after that. Literature helps to understand the law better. Yes, certainly. Nitesh is saying literature always has served in determining law on the basis of jurisprudence. Very good. Akanksha, the law is always interpreted in different ways. It's the language of law which is used. You have given the answer. All of you have given the answers. So my work is simple now. I just have to sum it up. See, law and literature are integrally related with each other. Have you watched a movie of late? If I ask you to think of 3 or 4 movies, there is an echo. Can someone please just turn off the mute the mics? Yeah. So if we think of 2 movies, 3 movies, out of that there is a great likelihood that you have seen a courtroom scene also. Even in the TV serials. What are movies? Movies are also a form of literature or an expression of literature. Likewise, if you read literature, whether it's Shakespeare, whether it is the Indian writers, you would see courtroom scenes there. One of the famous courtroom scenes is from Shakespeare's Merchant of Venice. And what is there in that scene? If you want, I can, yeah, literature is a window to the society. Great. So you would see there are a lot of concepts. Someone used the word jurisprudence. Let me elaborate a bit. Jurisprudence is the philosophy of law. For non-lawyers here, although this is a conference of lawyers. So that philosophy, that basic thinking of law, that has something integrally associated with literature. Literature is not just stories. Stories are not just stories. One the most efficient, most prominent ways of communicating knowledge is stories, telling a story. If you read Tagore, I have borrowed this thought from Tagore, right? So in stories, a lot of things about life, about society, about psychology, about philosophy is coded. And that becomes the source for picking up the basic theories, concepts, trends, ideologies of law. If we look at a movie, that's Merchant of Venice, scene 4, act 1, maybe I have mixed it up. Act 4, scene 1, what it is, whatever it is, the courtroom scene, in simple words. There are several concepts, many of you might have read this play, which can be deciphered, including about attempt to murder and murder. I think the jurisprudence was not clear. Yeah, Act 4, Scene 1, trial scene. Thank you very much, Mr. Amit Kumar. In good old days, I don't think there was a distinction between attempt to murder and murder, but this must have helped us in evolving this concept that attempt to murder is different and murder is different. In that scene, Portia allows a pound of flesh, and Shylock goes ahead with the intention of taking the pound of flesh, but is not able to take it because he was stopped. But still, there were charges of murder on him, and it was tried like murder. So this is a jurisprudential philosophical issue. It was found useful that there should be a distinction between the two. So in the Indian laws, we have this distinction now. Likewise, contract. Within that scene, there are so many things that we can think about. One day I was sitting with a couple of law teachers, and somehow they were talking about the Indian Contract Act, or the contract essentially. What is a contract? So a professor who was teaching law, a law of contracts, he defined it as an offer, acceptance of offer, and consideration. Right? I think many of you will correct me. Something is still missing. And that missing thing is very, very important. Akanksha ji, I think you want to say, add something.
It's enforceability of the
Yeah,
agreement.
what you said, I would have said it in some other words, but yes, essentially that. Essentially lawful consideration. Now, in the case of Shylock, everything was there. Offer was there, acceptance was there, right? Offer of money and pound of flesh if that money was not returned in time, and consideration, everything was there. But what was missing was lawful consideration, this small word, lawful. So how this must have come in Indian Contract Act? Let us talk just of Indian Contract Act, because across the jurisprudences, across the world, I think in modern jurisprudence, this is a constant. This concept is a must, lawful. So lawful came after analyzing literature. Literature must have given us this concept. Earlier, contracts have always been a part of our lives. It is an essential part. It is like language. Everything is a contract. Sometimes marriage is also considered a contract. In some cases, it is family law, we all know. Or in some cultures, it is not a contract, it's a sacrament, etc. But still, elements of contract are still there. It is not that. So contract has been there in, yeah, yes, Nitish, all parts of our life. But we have to be very clear what is lawful then. Then what is lawful? That has to evolve. That has evolved in the form of human rights. And human rights, I think they are also something that depends upon philosophy and literature. They are all integrated. They are not separate. If something is written in literature or something is depicted which is against the political correctness, then there can be repercussions. That is one thing. But the art is that even politically insignificant or politically incorrect things are depicted in literature. That is why freedom of speech is a must. That is why in our constitution, freedom of speech is given such an important place. Many of you might be law graduates. You might not have thought ever about the importance or why freedom of speech should be there. And freedom of speech is directly connected with literature. You have poetic license, writer's license. Why it is there? I think basically this poetic license is something that we were aware of. Even the kings, the courts, they allowed poetic license. You can write something with, there was creative freedom. Why it was there? So that you can explore new things. Like for example, in Merchant of Venice we were talking about, if the freedom of the writer was not there, then, and the freedom of interpretation of that scene, then many things would not have developed in law. I would have loved to explore this theme further, but I think now let us have a small discussion. I would have liked to even explore, we can spend one session if it is available someday, on Merchant of Venice and the concept of law. But let me steal 1 or 2 more minutes out of the question time. See, lawyers have been great writers across the world. And writers have also touched upon the themes of law. This is one of the important interrelationships between law and literature. When judgments are written, literature is quoted. Sometimes poetry is quoted, sometimes authors, other literature. Shakespeare is one of the most quoted figures in judgments. You can survey that. We have done some studies already. So this way, law and literature are interrelated. Let me again let me add another thought, and that is that for a well-rounded personality, technical education is not enough. You require literature, you require humanities, you require liberal thinking. Professional education is a race against time always, whether it is medical, engineering, or law. Within 5 years, a lot of acts, lot of laws, lot of principles of law have to be communicated. They have to be taught. And that gives little time for the person to grow. That is why it is essential that we should have an emphasis on literature, on language, communication, philosophy, history, etc. Thank you very much. 5 minutes are remaining. I welcome the questions.
Thanks a lot, sir, for a great lecture. Now, first of all, I introduce myself. I am Vatsal Chaudhary, teaching associate from Starex University. I'll be moderating the question answer session. So, first of all, a question that has intrigued me since my graduation days. It is generally said that the legal language is very complicated and thus is very difficult for a layman to understand it. What are your suggestions to make legal language more comprehensible for a common man?
That's a wonderful question, and I missed out on it.
May I repeat it, sir?
No. Thank you very much. It's clear to me. But if it is not clear to someone, you can repeat for them. Say, if you read authors like Peter Tiesma, who have done a lot of research on this, and even in National Law University Delhi, where I teach, we have undertaken many research projects, dozens of them, about this complexity of language and ways of resolving it. First of all, the causes of this complexity are there. Second, ways of resolving. There is a whole movement called plain language movement, which I think our university is leading in, but in India, but across the world, this is a big movement which is picking up, especially in US, Canada, Australia. I am aware of. The meaning is that the litigant is the end user. If you talk in terms of consumer rights, then end user is the final stakeholder of law or the process of law. If the language is such that the litigant is not able to understand what is going on in the matters of life, death, and property affecting them, then something is wrong with that language. So the thrust across the world is to make the language understandable. If you want, I can tell why this complexity is there. And if you want, I can suggest some remedies also. But if there are more questions, we will take them up because 2 minutes are remaining.
Okay, sir. Sir, another question that has been asked by Mr. Hemant is that does culture, gender, nationality, or social class have an effect on legal communication?
Certainly. I think I will request the organizers to share some of my publications. I have shared the publications. Please share them share the links here. So refer to one of my papers on intercultural communication. So there you would see an answer to this. And in brief, the answer is yes. Certainly, most definitively.
Sir, one more question has been asked by Ms. Divya. Her question is that what are the different barriers to the effective legal communications?
First of all, we can start with barriers to communication, but since we don't have the time, so let me just focus upon legal communication. The barriers in legal communication, 1 second, please. Go down. Yeah, this one. Or you can share. Yeah, fine. This one. We are sharing a link to the paper I just mentioned. No, put it in the message box. So one of the barriers is the technical nature of this language. Just paste it here. Wait. Yes, you can see it in the message also. One of the barriers is the technical nature. Technical nature of legal language is nothing unnatural. It is not even a three-lettered word. It is not an abuse. I don't denounce it. But sometimes out of laziness or even corrupt thinking, people overuse it, use it inappropriately, use it indiscriminately, use it everywhere. That is wrong. Law is a technical field. We have our own language or terminologies because of accuracy, because of tradition, because of understandability. That is right. But when the acts are enacted in the parliament, for example, and in some countries the precedents are there, there should be a parallel text in plain language. Plain language means the language of the ordinary person or lay person, which is easily understandable. It should not be very long sentences. It should not be full of terms, foreign terms, Latin terms. When I'm talking of English, law in English, it should not have a lot of maxims. All these things, it should not be formulaic, it should not have obsolete words, it should not have here to, there to, etc. expressions. So remove them, it will become simple. And another important thing about language of the law is, like in our country, we say that he subsumes or presumes she. That should also be eliminated. Gender bias in language should also go. Yes.
Taking up the last question.
I am there. I am free. You, last, if there are any number of questions, I can attempt answering them. But yeah, please suit your time.
Sir, Mr. Amit Kumar has asked, is there a relationship between art of advocacy and technicalities of legal relationship?
Art of advocacy and technicalities of
Legal relationship.
Can you please use plain language so that I understand? Sorry, I am not able to understand. This question is too complex for me. And technicalities of what do you mean by technicalities of legal relationship?
Mr. Amit, can you simplify your question?
Yeah, it will be a great help.
Technicalities of legal language.
So, oh, okay. So I thought it's a new concept, legal relationships. Can I go back to the question? Can I see that?
The relationship between art of advocacy and technicalities of legal language.
Certainly. See, technicalities of legal language, you have to be a master of language to be an advocate of any type, corporate, lawyer, to litigation lawyer, in litigation to a teacher of law. You must be a master of language. Master means above language, parangat. You have to be at another level. And that means you should have mastery over technical language, you should have mastery over the layperson's language, you should have mastery over the concepts. Now, language is a tool. Express yourself in whatever way you you are required to. The basic purpose is connecting with people, and the people may be the judge, the litigant, it can be your adversary, the opposite party. You have to connect, and the way of connecting is language. You have to use the language. Sometimes you have to use a technical language, sometimes you have to use a plain language, and sometimes people misuse language to intimidate others. That is malpractice. But any tool like a knife can be used the way you want, depending upon your intentions. A criminal can use a knife for killing people. A surgeon can use a knife for saving people. Likewise for language. This is all I can say in 30 seconds. Give me half an hour. Maybe I can elaborate it further.
Okay, sir. With this, those were some great responses, and with this, our question answer session comes to an end. Now, I invite Ms. Vasfa Sharma for vote of thanks.
Thank you. Thank you, Vatsal sir. And thanks a lot, sir, for such a knowledgeable and wonderful session. You have enlightened us on the importance of language, literature, and communication skills in the curriculum of law and legal research. You have also talked about academic caste.
Well, I really believe that some great words of thanks are being shared, and I thank you for that.
Yes, sir. Thank you, sir. Thanks a lot, sir.
Welcome, madam.
So, okay, sir. So, in addition to this, we have also talked about the language and communication. These both are the essential requirements in law. And you also enlightened us, like at legislative level also, law commission drafting and the language plays a very important role in legal field. Also, other aspects are also discussed by you, like verbal, non-verbal, and paralinguistic modes were also included by you. So this session was, you can say, like very much important for us and very knowledgeable for all participants. And participants, I thank you all for joining this session. And thank you, sir, once again for this wonderful session. Thanks a lot.
Thank you very much.
Thank you, sir.
Thank you, sir.
Participants are requested to fill out the feedback forms before leaving the meeting.
Participant kindly fill the feedback form and we will be ending the session in 5 minutes.